Okay, I'm going to read a case titled RBC Capital Markets LLC versus Jervis. This is heard by the Delaware Supreme Court in 2015. I'm on page 615 of Corporations Chapter 10, the duty of loyalty, within Section 1 about self-interested transactions. I'm going to try to move quickly just to cover many pages that should have been read before spring break. RBC Capital, an investment bank, was engaged to advise Rural Metro Corp in its sale to a private equity firm. Warburg Pincus RBC was eager for the sale to go forward, as it would not only receive fees for advertising Rural, but would also garner significant fees for Warburg in connection with RBC having facilitated the loan that Warburg needed to complete the acquisition. So they're negotiating a sale also involved in lending. Okay. So advisement fees as well as serving as a lender. Rural's special negotiating committee believed that Warburg's offer was inadequate and recommended that the Rural board not accept the offer. Rural had 7 directors, although one did not vote on the sale to Warburg. Before the board meeting, RBC aligned itself with Rural's CEO, DiMino, who was also a director. DiMino was eager for the sale to Warburg to proceed, as he would be continued in his position. This is called entrenchment. Kind of its potential self-interest motivation. In his position following Warburg's purchase, another board member, Shackleton, was the managing partner of a hedge fund with a substantial ownership position in Rural, who was eager to monetize its holdings in Rural through an M&A event. So you've got DiMino's motivation here. You've got Shackleton's motivation as a managing partner of a hedge fund with substantial ownership in Rural. A third director, Davis, was under growing pressure from ISS because he served on too many corporate boards, a dozen. Hence, the disappearance of Rural would reduce his board memberships and save to some extent ISS concerns that he was overboarded. Interesting. These facts caused the court to conclude that each of the 3 had personal circumstances that inclined them to a near-term sale of the company. Shareholders sued, alleging the directors breached their duty of loyalty and joined RBC as an aider and abettor. The individual defendants settled, paying collectively $11 million. The trial proceeded against RBC. The court found that the directors breached their fiduciary duty by failing to take reasonable steps to attain the best value for the Rural shareholders. The court also found that their breach was facilitated by RBC, who, among other actions, deliberately reworked its fairness opinion to lower its appraised value of Rural so that Warburg's offer appeared to be more attractive. It also worked closely with DiMino, Shackleton, and Davis in the days between the special committee's recommendation and the board meeting to win approval at the board level. Moreover, RBC was involved in the proxy statement's failure to disclose RBC's own conflicts of interest, so that rural shareholders were denied this information when approving the sale. Applying the following four-part test, the court held RBC liable as an aider and abettor to the director's breaches. 1, the existence of a fiduciary relationship. 2, the breach of the fiduciary's duty. 3, knowing participation in that breach by the defendant. And 4, damages proximately caused by the breach. The court elaborated on the third element, observing knowing participation in the board's fiduciary breach requires that the third party act with the knowledge that the conduct advocated or assisted constitutes a breach. The Supreme Court reviewed the multiple facts supporting the trial court's finding that RBC acted with the requisite scienter. RBC knowingly induced the breach by exploiting its own conflicted interests to the detriment of rural and by creating an informational vacuum. RBC's knowing participation included its failure to disclose its interest in obtaining a financing role in the EMS transaction and how it planned to use its engagement as rural advisor to capture buy-side financing work from bidders for EMS. Its knowledge that the board and special committee were uninformed about rural's value and its failure to disclose to the board its interest in providing the winning bidder in the rural process with buy-side financing, and its 11th hour attempts to secure that role while simultaneously leading the negotiations on price. RBC's desire for Warburg's business also manifested itself in its financial analysis provided by RBC the day the board approves the merger. RBC's illicit manipulation of the board's deliberative process for self-interested purposes was enabled in part by the board's own lack of oversight, affording RBC an opportunity to indulge in the misconduct that occurred. The board was unaware of RBC's modifications to the valuation analysis, back-channel communications with Warburg, an 11th hour attempt to capture at least a portion of the acquirer's buy-side financing business. RBC made no effort to advise the rural directors about these contextually shaping points. The result was a poorly timed sale at a price that was not the product of appropriate efforts to obtain the best value reasonably available. And as the trial court found, the failure to recognize that rural standalone value exceeded the sale price. RBC Capital was held liable for nearly $76 million for its role is enabling directors of Rural Metro Corporation to violate their fiduciary obligations. Shocking Technologies is the next case. On page 617, still in self-interested transactions. Clearly, the point of finding a duty of loyalty breach requires some self-interest factors, and the analysis is this four-part test kind of shows that. 1, existence. So on page 615, existence of a fiduciary relationship. Breach. of the fiduciary duty. Knowledge, which we just talked about. Scienter, which is knowing participation in the breach by the defendant. And lastly, damages. So it doesn't require in this 4-part test that there be self-interest, but perhaps that is a significant component of the knowing participation prong. So if it's proven, there's just much more likelihood of liability being found, scienter being found, and liability being applied. So, so RBC acted as advisor and lender in M&A transaction. And then there's a good part of other facts. So the trial court found liability for breach of duty. Kind of like the directors failed to take appropriate efforts to obtain the best value. To use best efforts to obtain best value. And they affirmed at the appeal court level. So moving on to shocking technologies on page 617, Court of Chancery of Delaware 2012 opinion. As part of his strategy to gain an additional board seat for a group of investors with whom he believed he shared a common objective, the director, Simon Michael, who was aware that the company was in dire financial condition and in need of the infusion of funds, sought to dissuade the only remaining potential investor from investing in the company. In doing so, he shared confidential company information with the potential investor. Michael believed he would be more likely to achieve his goals if either the potential investor withheld any additional information in the company, or the potential investor used the confidential information to get a better deal for its investment. Michael believed that either outcome would undercut the authority of the other members of the company's board of directors and thereby strengthen his ability to persuade them to pursue what he believed was a better plan to revive the company. Michael hoped that his disclosure of confidential information to Dickinson would have ultimately resulted in better corporate governance practices for Shocking. That hope, however, cannot outweigh or somehow otherwise counterbalance the foreseeable harm that he would likely cause to Shocking. Notwithstanding his good intentions, his taking steps that would foreseeably cause significant harm to Shocking amounts to nothing less than a breach of fiduciary duty of loyalty. Michael has referred to this as short-term pain for short-term gain. Perhaps it is a matter of degree. Advancing a policy where short-term adverse effects are outweighed by future benefits may be the product of prudent and dutiful fiduciary. This is a crazy theory, but I mean, it's not so crazy. He still, is sharing confidential information. In theory, there may be something of continuum on which actions such as Michael's should be measured, where the line is between acceptable and unacceptable is not readily pinpointed. The circumstances of this case, however, leave little, if any, room for doubt. First, the short-term financial consequences of Michael's antics could have caused the demise of Shocking. Such reasonably foreseeable outcomes cannot be reconciled with the exercise of fiduciary duty. Second, the disclosure of confidential information to the potential investor or an adverse party at the particular moment, especially when the director knows and hopes that the disclosure would benefit the potential investor to the substantial detriment of the company, is conduct which, in and of itself, is a breach of duty of loyalty. In short, the loyal director does not put the company in dire financial circumstances in order to obtain what he perceives as a benefit for himself and his associated investors. That there may be some theoretical improvement in corporate governance to a director's liking does not alter this conclusion. And that's all you get out of that's all you get out of this case. But that's the really important takeaway. So the theory of short-term pain for long-term gain as a shield, a business judgment shield is unavailable if conduct could ruin the company. If conduct could ruin the company, and two, there's a disclosure of confidential information. And while I didn't see the actual facts for it, there's a benefit to I'm guessing Michael is a director. Yep. Simon Michael to a director, an investor / adverse party. So that's the pain factor. And the gain factor is supposed to be increased corporate governance. And there's just doesn't reconcile. And the point is, it never will. This is just too clear cut. So on a continuum, the analysis allows some a certain continuum to test that theory, but here it's too clear cut. So, in the paragraph that follows, assume the facts and shocking technologies show that Michael met with a group of shareholders and learned that they plan to launch a campaign to elect themselves to the board, and if successful, would appoint Michael as the future CEO of the firm. He thereafter provided them with a list of stockholders, including their holdings and addresses, as well as the company bylaws. Would this change the result? And then you've got an analysis here by Matthew D. Kane, Jill E. Fish, Sean J. Griffith, and Stephen David Dorr Solomon. How corporate governance is made, the case of the golden leash. This is a Pennsylvania Law Review article. How is corporate governance made? Oh, and it's dated 2016. We use, where's my bookmark? We use a case study of a corporate governance innovation, the Golden Leash, to shed light on how corporate governance originates and how it is valued. Activist hedge funds invented the Golden Leash as a tool for attracting and incentivizing director candidates as a proxy contest. Under the terms of the Golden Leash, these hedge funds agreed to pay the director nominees millions of dollars if the nominees were successful both in winning board seats and achieving the hedge fund's desired objectives. The Golden Leash burst onto the scene in 2012 when JANA Partners offered to pay its nominees to the board of Agricom Inc. an additional $50,000 each if elected, plus a collective total of 2.6% of JANA's net gain on the investment. Around the same time, Elliott agreed to pay its dissident nominees to the Hess Corp board an additional $30,000 if elected for each percentage point by which Hess outperformed its peers over a 3-year period. Opponents of the arrangements dubbed them golden leashes. So this is kind of the definition. Activist hedge funds invented a golden leash as a tool for attracting and incentivizing director candidates in a proxy contest by agreeing to pay them and winning board seats, which is kind of the hypothetical that was just given in the last paragraph. So that's the rule for golden leash. Make sure to return to this concept. Actually, I'll write it down in my book notes. Where's that? So on page 618. And I'll mark it. The Golden Leash was immediately controversial. JANA and Elliott justify the Golden Leash by the need first to get the right people onto their slates and second to incentivize those people once elected to push the company to outperform. According to this account, Golden Leashes empower shareholders to by providing directors committed to unlocking hidden value and increasing market returns. Critics of the Golden Leash, however, derided these arrangements as pernicious innovations that nearly emboldened those who would jeopardize the company's ability to generate sustainable long-term returns and destroy jobs. Opponents of activist shareholders soon responded with an innovation of their own. In May 10, 2013, Martin Lipton of Wachtell Lipton, Rosen & Katz Wachtell, a prominent law firm known for defending firms against activist interventions and hostile takeovers, issued a public memorandum recommending that corporations adopt bylaws prohibiting Golden Leash compensation arrangements, the Wachtell bylaw. In relatively short order, more than 30 public companies adopted the Wachtell bylaw. Prohibits Golden Leash in what type of a document? I guess just bylaws. Moreover, because it would be adopted by any company virtually overnight, the Watchtell bylaw had a market-wide effect. The Watchtell bylaw was challenged, but not in any court of law. Instead, it provoked the wrath of a prominent proxy advisory firm, Institutional Shareholder Services. On November 12th of 2013, ISS recommended that shareholders withhold their votes from directors at Provident Financial Holdings, Provident, because the bank had adopted the Watchtell bylaw. At the subsequent annual meeting, Provident's director nominees received a substantial number of withhold votes, and ISS threatened more withhold recommendations, publishing a list of other firms that had adopted the Watchtell bylaw. Corporate America got the message. By May 20th, 2014, 28 of the 32 companies known to have adopted the Watchtell bylaw prior to the Provident meeting had removed it in whole or in part. The Golden Leash in contrast is far from dead. It has been used in several recent activist attacks. The back and forth on the Golden Leash by the Watchtell bylaw provides a case study of how corporate governance originates and is tested by the marketplace. The Golden Leash shows that corporate governance in many cases is a product of governance intermediaries, each with its own agenda and interests. Activist hedge funds may have invented the Golden Leash, but the shape of the governance arrangements that ultimately emerge has as much to do with the counseling of a corporate law firm and the advocacy of an institutional proxy advisor as it does with the activists themselves. The success or failure of a governance innovation may often depend upon the position taken by such intermediaries. While intermediaries may introduce these provisions, the question remains whether they are beneficial to the companies adopting them. With respect to the Golden Leash, this can be studied empirically. We did so by first examining each company when the circumstances of its adoption and repeal of the Golden Leash bylaw. We found that while some firms were reacting directly to activist threats, others had no apparent rationale for adopting the Watchtell bylaw. Second, if the Golden Leash is economically good or bad, one would expect to see stock price reactions, either positive or negative, in response to firms' adoption and repeal of the Watchtell bylaw. We therefore ran a time series analysis to determine how the market reacted to firms' adoption and repeal of the new corporate governance terms. We found no statistically significant share price effect for those companies that had adopted and subsequently repealed the Watchtell bylaw. We then look further because the Golden Leash bylaw can be adopted unilaterally at any time by the board of directors. We posited that what matters is not the actual adoption of the bylaw, but rather the bylaw's availability for adoption if and when the board decides that it is needed. Additionally, we reason that the availability of a Golden Leash may not matter for all companies, but only for those that face the imminent prospect of proxy contest or other activist intervention. That's when there's a meaningful financial relationship between the bylaw and the stock price. So we examine this possibility by looking at the companies that experienced shareholder activism during the period from 1 year prior to the Watchtell Memorandum to 1 year after the Provident annual meeting. We assume market discrimination in pricing corporate governance terms and hypothesize that we would find a share price reaction to the Watchtell Memorandum in the subset of companies. Our results are consistent with our hypothesis, so we found a statistically significant decline in the share price of targeted firms on the release of Watchtell Memorandum and a significant increase in the share price after the Provident vote. Consistent with our theoretical predictions, these price effects were limited to those companies most affected by the governance innovation in question, that is, those companies most likely to experience activism. Companies not subject to activist intervention had no statistically significant share price reductions. Our findings contain several important implications for corporate governance. First, they provide evidence that intermediaries play an important role in channeling corporate governance innovation. Second, they show that, at least in this case, corporate governance may be priced by the market, although our results suggest that innovators respond to developments regarding the golden leash. We note that the value assigned by the market may not reflect the economic value of the leash itself, but may instead indicate more general investor or market anticipation of potential activist intervention. Third, our empirical findings provide evidence that investor reactions may be based largely on salience, and governance intermediaries play a critical role in creating this salience. Ultimately, our findings are cause for caution regarding what constitutes good corporate governance and how studies of governance are conducted. While our case study examines only one event, it offers reasons to question the relationship between short-term share price reactions and long-term economic value. More generally, the evolution of corporate governance innovations is a complex story involving the actions and reactions not merely of the firm and shareholders, but of a variety of intermediaries and interest groups with their own agendas. The obvious concern, that's the end of the excerpt. I don't define any of this as corporate governance, so they just kind of titled it corporate governance, but it's, in my mind, not what that term is used to define in practice within a corporation. The obvious concern posed by golden leashes is not just whether the arrangement tethers the leash director to the shareholders' overlapping interests, but the degree to which the shareholders' interests are congruent with those of the leash director. For a fulsome analysis of these concerns, see Gregory H. Schill, The Golden Leash and the Fiduciary Duty of Loyalty. What problem arises if the arrangement between the leash director and the hedge fund is not fully disclosed? Consider Redding versus Attorney General, examined in Chapter 1. Section 2, disclosure of such a third-party payment is mandated for reporting companies by various SEC rules. So corporate leashes have to be, golden leashes must be disclosed. That's crazy. I'll just say per SEC. I'm not sure how that in practice is actually done, but anyway, we're now moving to a new section called self-dealing transactions. A common law is the first section, and there's going to be a article here, but it's outlined. I like it. It says Marsh are directors, trustees, conflicts of interest, and corporate morality is the name of the article. The sections are prohibition, going back to the 1880s, approval by a disinterested majority of the board, and judicial review of the fairness of the transaction. So I'm going to read it quickly. It seems like it'll give us a historical context. In 1880, it could have been stated with confidence that in the United States, the general rule was that any contract between a director and his corporation was voidable at the instance of the corporation or its shareholders without regard to the fairness or unfairness of the transaction. This rule was stated in powerful terms by a number of our highly regarded courts and judges in cases which arose generally out of the railroad frauds of the 1860s and 1870s. The general rule was that any contract between a director and his corporation was voidable at the instance of the corporation or its shareholders without regard to the fairness of the transaction. So that's kind of huge. I want to write that down. It's the general rule of like the 1860s through 80s per railroad fraud is that contracts between director and corporation are voidable at instance of shareholders regardless of fairness analysis. And I believe, so it was stated by the courts. Was it upheld, or how long was it upheld? Probably eventually crumbled. Under this rule, it mattered not the slightest that there was a majority of so-called disinterested directors who approved the contract. The court stated that the corporation was entitled to the unprejudiced judgment and advice of all of its directors, and therefore it did no good to say that the interested director did not participate in the making of the contract on behalf of the corporation. The very words in which he asserts his right declare his wrong. He ought to have participated. Furthermore, the court said that it was impossible to measure the influence which one director might have over his associates, even though ostensibly abstaining from participation in the discussion or vote. A corporation, in order to defeat a contract entered into by directors in which one or more of them had a private interest, is not bound to show that the influence of the director or directors having the private interest determine the action of the board. The law cannot accurately measure the influence of a trustee with his associates, nor will it enter into the inquiry. Perhaps the strongest reason for this inflexibility of the law was given by the Maryland Supreme Court, which stated that when a contract is given with even one of its directors, the remaining directors are placed in the embarrassing and invidious position of having to pass upon, scrutinize, and check the transactions and accounts of one of their own body with whom they are associated on terms of equality in the general management of the affairs of the corporation. It's like immediately suspect. So I'm going to give page 622 MD Supreme Court opinion. Placed in the embarrassing and invidious position of having to pass blah, blah, blah. Or as Justice Davies of the New York Supreme Court, that's from Cumberland Coal and Iron Company Parish in 1875, actually. Or as Justice Davies of the New York Supreme Court expressed in the same thought, the moment the directors permit one or more of their number to deal with the property of its stockholders, they surrender their own independence and self-control. See, this seems like the founding of corporate governance to me. This rule applied not only to the individual contracts with directors, but also with the situation of interlocking directories, heard that word before, directorates, where even a minority of the boards are common to the two contracting corporations. Not only that, it was also applied to a situation where one corporation owned a majority of the stock of another and appointed its directors, even though they may not be the same men as sat on the board of the parent corporation. This principle absolutely inhibiting contracts between a corporation and its directors, or any of them, appeared to be impregnable in 1880. It was stated in ringing terms by virtually every decided case, with arguments which seemed irrefutable, and it was sanctioned by age. As Justice Davies stated, to hold otherwise would be to overturn principles of equity which have been regarded as well settled since the days of Lord Keeper Bridgeman in the 22nd of Charles II to the present time, principles enunciated and enforced by Hardwicke, Thoreau, Lord Loughborough, Eldon, Cranworth, Story, and Kent, and which the highest courts of our country have declared to be founded on immutable truth and justices, and to stand upon our great moral obligation to refrain from placing ourselves in relations which excite a conflict between self-interest and integrity. 30 years later, this principle was dead. Approval by a disinterested majority of the board. So this is the second section. It could have been stated with reasonable confidence in 1910 that the general rule that was a contract between a director and his corporation was valid if it was approved by a disinterested majority of his fellow directors and was not found to be unfair or fraudulent by a court if challenged. So, figures. So I need another color pen here to show the element that was eliminated had to do with disinterested directors. But that a contract with the majority of the board was interested was voidable at the instance of the corporation or its shareholders without regard to any question of fairness. One searches in vain in the decided cases for a reasoned defense of this change in legal philosophy or for the slightest attempt to refute the powerful arguments which have been made in support of the previous rule. Did the court discover in the last quarter of the 19th century that greed was no longer a factor in human conduct? If so, they did not share the basis of this discovery with the public, nor did they humbly admit their error when confronted with the next wave of corporate frauds arising out of the era of the formation of the trusts during the 1890s and early 1900s. The only explanation which seems to have been given for this change in position was the technical one that a trustee, while forbidden to deal with himself in connection with trust property, could deal directly with the Sasuke Trust if he made full disclosure and took no unfair advantage, and that the case of a director who abstained from representing the corporation but dealt in his personal capacity with the majority of disinterested directors was properly analogized to a trustee dealing with the Sasuke Trust, as the Texas court said. We think it is not true that one who holds the position of director. So the only explanation is trustee dealing with this K trust. I think is analogy of the whatever. Where was I? We think it is not true that one who holds the position of director is incapable under all circumstances of divesting himself of his representative character in a particular transaction and dealing with the corporation through others competent to represent it, as other trustees may deal directly with other beneficiaries. The company is represented by those who alone can act for it, and if they are disinterested, he can, we think, deal with them as any other trustee can deal with the Sasuke Trust if he makes a full disclosure of all facts known to him about the subject, takes no advantage of the position, deals honestly and openly, and concludes a contract fair and beneficial to the company. So this is your analogy. And again, trust analogies literally thrust corporate law ahead and again. But in no case is there any discussion or attempted refutation of the reasons previously given by the courts as to why it is impossible in such a situation for any director to be disinterested. Some courts seem simply to admit that the practice has grown too widespread for them to cope with. In Southside Trust Co. versus Washington Tin Plate Co., the Supreme Court of Pennsylvania said the interests of corporations are sometimes so interwoven that it is desirable to have joint representatives in their respective managements, and at any rate, it is not uncommon and therefore not unlawful practice. Under the rule that a disinterested majority of the directors must approve the transaction with one of their number, the question arose whether this meant a disinterested quorum, i.e., normally a majority of the whole board, and merely a disinterested majority of a quorum, so that the interested director. It's a good question. So that the interested director or directors could be counted to make up the quorum. Virtually all of the cases held that the interested director could not be counted for quorum purposes. As a California court, said the interested director for this purpose was as much a stranger to the board as if he never had been elected a director. And the last part, only one section, is judicial review of the fairness of the transaction. By 1960, it could be said with some assurance that the general rule was that no transaction of a corporation with any or all of its directors was automatically voidable as the suit of a shareholder, whether there was a disinterested majority of the board or not, but that the courts would review such a contract and subject it to rigid and careful scrutiny, and would invalidate the contract if it was found to be unfair to the corporation. So this is just the whole concept. General rule is like completely reduced to really one factor, which is fairness to the company. And then you get several rules or codes of law here in Part B, statutory approach. And then you come to the first case, Lewis versus SL&E in this section. And that's a pretty lengthy case, about 7 pages long. It's from 1980, United States Court of Appeals. It's on page 625 through 632. Keir Circuit Judge. This case arises out of an intra-family dispute over the management of two closely held affiliated corporations. Plaintiff Donald E. Lewis Donald, a shareholder of SL&E Inc., appeals from judgments entered against him in the United States District Court for the Western District of New York. Harold P. Burke, judge, after a bench trial of his derivative claim against shareholders SLE and of a claim asserted against him by the other corporation, Lewis General Tires, Inc. So these are kind of the companies. And you've got the bench here. And you've got closely held affiliated corporations. The defendants, Allen, which intervened. Okay, so they intervened in the court. LGT, that is, that corporation and the other corporation. The defendants, Alan E. Lewis and Leon E. Lewis and Richard Lewis, are all brothers of Donald. They were, at pertinent times herein, directors of SLE and officers, directors, and shareholders of LGT. Donald charged that his brothers had wasted the assets of SLE by causing SLE to lease business premises to LGT from 1966 to 1972 at an unreasonably low rental. LGT was permitted to intervene in the action and filed a complaint seeking specific performance of an agreement by Donald to sell his SLE stock to LGT in 1972. The district court held that Donald had failed to prove waste by the defendant directors and entered judgment in their favor. The court also, so I'm going to say waste, not proven. The court also awarded attorney fees to the defendant directors and to SLE and granted LGT specific performance of Donald's agreement to sell his SLE stock. NSLE to LGT. So, with LGT are closely held affiliated corporations intervening in suit. I'm guessing Donald is the plaintiff. Okay, plaintiff. Now, on appeal, plaintiff argues that the district court improperly allocated him the burden of proving his claims of waste, and that since defendants failed to prove that the transactions in question were fair and reasonable, he was entitled to judgment. So it's a burden of proof inquiry. Donald also argues that the awards of attorney fees were improper. We agree with each of these conventions and therefore reverse and remand. Cool. For many years, Leon Lewis Sr., the father of Donald and defendant directors, was the principal shareholder of SLE and LGT. LGT, formed in 1933, operated a tire dealership in Rochester, New York. SLE, formed in 1943, owned the land and complex of buildings at 260 East Avenue in Rochester. This property was SLE's only significant asset. Prior to 1956, LGT occupied SLE's premises without benefit of a lease. The rent paid was initially $200 per month and had increased over the years to $800 per month by 1956 when additional parcels were added. On February 28th of 1956, SLE granted LGT a 10-year lease on the newly expanded property. The property for rent of $1,200 per month or $14,400 per year. Under the terms of the lease, SLE. So who's who? Just trying to figure this out. So SLE's only significant asset. Okay, so this one's the landlord, basically, and LGT is the tenant, basically. All right. Under the terms of the lease, landlord is responsible for payment of real estate taxes on the property, while all other current expenses were to be borne by the tenant, LGT. In 1962, Leon Lewis Sr. transferred his SLE stocks, 90 shares in all, to his 6 children, defendants Richard, Allen, and Leon, Jr., plaintiff Donald, and 2 daughters, Margaret and Carol, giving 15 shares to each. At that time, Richard, Allen, and Leon were already shareholders, officers, and directors of LGT. Contemporaneously with the receipt of SLE stock, all 6 of the children entered into shareholders' agreement with LGT, under which each child who was not a shareholder of LGT during June 1, 1972 would be required to sell his or her SLE shares to LGT within 30 days of that date at a price equal to the book value of the SLE stock. Okay. LGT's lease on the SLE property expired on February 28, 1966. At that time, the directors of SLE were Richard, Allen, Leon Sr., Henry Etzberger. These 5 were also the directors of LGT. It shows their ownership interests. I don't really care. When the lease expired in 1966, no new lease was entered into. LGT nonetheless continued to occupy the property and pay SLE at the old rate of $14,400 per year. According to the defendant's testimony at trial, there was never any thought or discussion among the SLE directors of entering into a new lease or of increasing the rent. Richard testified, "We never gave consideration to a new lease. From all that appears, the defendant directors viewed SLE as existing purely for the benefit of LGT. Richard testified, for example, that although real estate taxes rose sharply during the period from approximately $7,800 to more than $11,000 to be paid by SLE out of its constant $14,400 rental income, raising the rent was never mentioned. He testified that SLE was only a shell to protect the operating company." When the suit was commenced, there had not been a formal meeting of either the shareholders or the director of the SLE since 1962. Richard Allen Leon had largely ignored SLE's separate corporate existence and disregarded the fact that SLE had shareholders who were not shareholders of LGT and who therefore could not profit from actions used SLE solely for the benefit of LGT. That's kind of true. So these are material facts because that's when the court has in the past considered these shareholders like captive. They can't sell and they can't make money on their investment. Here they could sell, according to shareholder agreement way back. I say way back, but that was 1972. And right now we're talking about how the lease was kind of the same since 1962. And it's now 1980. So neither Donald nor his sisters ever owned LGT stock. As the June 1972 date approached for the required sale of their SLE stock to LGT, Donald apparently came to believe that SLE's book value was lower than it should have been. He sought SLE financial information from Richard, who had been president of SLE since 1967. Richard refused to provide information. Okay, so he sought information and was refused. Donald therefore refused to sell its SLE shares in 1972 and commenced a shareholder derivative action in the district court in August of 1973, basing jurisdiction on diversity of citizenship. That was stupid. The sole claim raised in the complaint was that the defendant directors had wasted the assets of SLE by grossly undercharging LGT for the later's occupancy and use of the property. Although the complaint charged such mismanagement for the period of 1962 to 1973, plaintiffs subsequently limited this claim to the period between February 28, 1966, the date on which the lease expired, and June 1, 1972, the date contractually set for valuation of SLE shares, which plaintiff had agreed to sell to LGT. LGT intervened and demanded specific performance of Donald's agreement to sell his SLE stock. Donald did not contest his ultimate obligation to sell, but took the position that since the book value of the shares would be increased if he prevailed on his derivative claim, specific performance should be granted only after adjudication of that claim. So this is like, I don't know, this is all in federal court. I find that ridiculous to believe. So federal court, intervention, it's like a counterclaim and for specific performance, and this is his counter argument. So the counterclaim, they're insured an 8-day bench trial at which plaintiffs sought to prove by the testimony of several expert witnesses that the fair rental value of the property was greater than $14,400 per year, that SLE have been paid by LGT. Defendants sought to show that the rental paid was reasonable by offering evidence concerning the financial straits of LGT, the cost of LGT of operating property, the general economic decline of the East Avenue neighborhood and rentals paid on 2 other properties in that neighborhood. LGT presented expert testimony that the value of plaintiff's stock as of June 1972, assuming the successful defense of the derivative claims was $15,650. The what? That's a stock price? Of which they've got somewhere around 90 in total. What's that number? That's like definitely over $1 million, I think. I mean, well over, almost more than that. The district court subsequently filed lengthy and detailed findings of facts and conclusions of law. Many of the court's findings went to the validity and probative value of the testimony given by plaintiff's experts, witnesses, and the court ultimately declined to credit that testimony. On this basis, the court held that Donald failed to establish the rental value of the property during the period at issue, and that defendants were just therefore entitled to judgment on the derivative claims. Implicit in the district court's ruling granting judgment for defendants upon the plaintiff's failure to prove waste was a determination the plaintiff bore the burden of proof on that issue. The court also ruled that LGT was entitled to specific performance on Donald's agreement to sell his SLE stock, and that Donald was not entitled to recover attorney's fees from SLE, but that SLE was and the individual defendants were entitled to attorney's fees from Donald. This appeal followed. Turning on the first question of burden of proof, we conclude that the district court erred in placing upon the plaintiff the burden of proving waste because the directors of SLE were also officers, directors, and/or shareholders of LGT. The burden was on the defendant directors to demonstrate that the transactions between SLE and LGT were fair and reasonable. New York Business Corporation Law, BCL, Section 713B and A3, which was repealed, and some case law here, Cohen versus Ayers of 1979, construing the section, as well as Rimillard Brick Co. versus Rimillard Dandini Co. in California, on California Corporations Code 820, upon which the prior BCL was patterned. Under normal circumstances, the directors of a corporation may determine in the existence of their business judgment what contracts the corporation will enter into and what consideration is adequate without review of the merits of their decisions by the courts. The business judgment rule places a heavy burden on shareholders who would attack corporate transactions. And you see Galef versus Alexander of 1980, Auerbach versus Bennett of 1979, and those were both New York, or at least the second district in New York. Fletcher, Encyclopedia of the Law of Private Corporations, Section 1039 of 1975, but the business judgment rule presupposes that directors have no conflict of interest. Okay. Well, that explains why it's so important, and to a finding of a breach of duty. It's because it assumes there's no conflict of interest, so destroy that presumption. I can't believe I'm just learning this now. When a shareholder attacks a transaction in which the directors have an interest other than as directors of the corporation, the directors may not escape review of the merits of the transaction. At common law, such a transaction was voidable unless shown by its proponent to be fair and reasonable to the corporation. BCL 713 in both its current and prior versions carries forward this common law principle and provides special rules of scrutiny of a transaction between the corporation and an entity in which its directors and directors or officers or have a substantial financial interest. The current version of Section 713, which became effective in September of 1971 and governs at least so much of the dealing between SLE and LGT as occurred after that date, expressly provides that a contract between a corporation and an entity in which its directors are interested may be set aside unless the proponent of the contract shall establish affirmatively that the contract and or transaction was fair and reasonable as to the corporation at the time it was approved by the board. That's the actual rule language. Thus, when the transaction is challenged in a derivative action against the interested directors, they have a burden of proving that the transaction was fair and reasonable to the corporation. So that's the part of the rule as it pertains to the burden of proof. The same was true under the predecessor to Section 713B, former 713A3, which was in effect prior to September 1, 1971. During the entire period of 66 to 72, Richard Allen and Leon Jr. were directors of both companies. There were no SLE directors who were not also directors of LGT. Richard Allen and Leon Jr. were all shareholders of LGT in 1966, and from 1967 to 1972, Richard and Leon Jr. were the sole shareholders of LGT. Under BCL 713, therefore, Richard Allen and Leon Jr. had the burden of proving that $14,400 was a fair and reasonable annual rent for the SLE property for the period from February 28th, 1966 through June 1, 1972. Our review of the record convinces us that defendants failed to carry their burden. At trial, there was no direct testimony as to what would have been a fair rental during the relevant period. That's right. Okay, so they kind of discounted the plaintiff's witness, I noticed. So the lease between SLE, the landlord, and LGT, the tenant, SLE is owned by, 6 or so directors, whereas LGT is owned by sub-segment of 3 to 4 common directors. Never reviewed since term in 1966, and from 1966 to 1972, date of sale of shares per shareholder agreement. When Dad divested shares, I think, to his children, was okay. So contested by plaintiff, a captive board of director to SLE when LGT refused to provide info. Plaintiff's expert discounted in fact-finding at trial court to prove waste. But the issue is that defendant burden of proof to show, what was it again? Fair and reasonable transaction was fair and reasonable per BCL 713, today and historically, which I'll put the rule here, but it basically says that. And so now we're kind of getting into the analysis. Defendants, expert witnesses, comps were won the day, but lost on appeal. So because they didn't propose a fair contract price. So where do we leave off? Right. Right, that's where we left off. Quite clearly, Richard Allen and Leon Jr. made no effort to determine contemporaneously what rental would be fair during the years of 1966 to 72. The review was that the rent should simply cover expenses, that the SLE existed for the benefit of LGT. During this period, no appraisals were made, no attempts were made to sell or rent the property. So a couple other factors is that no appraisals were made or relet attempted, and it's being considered, it's kind of important, no separate existence observed, and that SLE servient to LGT. Those are a couple of propositions that are important factors. Now, where was that? Defendants offered and said evidence of rents paid by other properties. Among their best evidence was the expert testimony of Harvey Rosenblum, a real estate appraiser. So comps, right? Rosenblum testified that two other East Avenue buildings, which the district court found to be comparable to the premises, were leased at lower per square foot rentals than was paid by LGT to SLE. However, as to one of these properties, Rosenblum testified only to rent paid during 1 year. So it's like not a fair comparison. And did not consider the whole period. As to the other property, Rosenblum described a 15-year lease that was entered into. This is comp 2. Comp 1. 15-year. The testimony, while perhaps not wholly irrelevant to the issues in the suit, fell short of demonstrating what rental the property could have fetched in 1966 or in any other relevant years. Indeed, Rosenblum himself testified that rental value could well be different for each year of the period. Thus, rentals that Rosenblum testified were agreed to in 1961 and 73 might well have been unfair in 1966 or 1967. This evidence could not support a finding that defendants acted fairly in maintaining an annual rental of $14,400 during the years from 1966 to 1972. Defendants also produced considerable evidence that over the relevant period, the East End neighborhood had been on an economic decline, that businesses were leaving the area, urban renewal projects had increased crime and depressed property values there, and that the area had in general become a less desirable place to do business. There was also evidence of specific development that had an adverse effect on the property. For example, the street running along one side of the property was made a one-way street, thus limiting the customers' access to LGT premises. The district court credited all of this testimony, and it was fair to say the defendants proved that there was a general downward trend in the value of the property. However, as noted above, defendants did not establish that this what was a fair rental value for the property in 1966. Absent such point of reference, a general downward trend in value is of no assistance in determining whether the rental actually paid was fair and reasonable during the ensuing years. Moreover, working in inverse, some of the defendants' own evidence as the value of the property at the end of the relevant period, suggesting that 14.4 was less than a fair rental in 1966, that the figure of $38,099 estimated by plaintiff's expert was perhaps not far off the mark. There was a variety of evidence suggesting that in 1972, the property was worth more than $200,000. An appraisal by defendant witness Harold Grunert in 1972 set the fair market price value of the property as of June 30th, 1972 at $220,000. In 1972, Leon Jr. had offered personally to buy the property for $200,000, an offer which Richard had rejected. And in 1972, Richard had informed Donald that evaluations by another appraiser, Harold Galloway, had set the value of the property at $200,000 and $236,000. Second defendant experts witness Rosenblum asked what would be a fair rent for the property. With given Grunert's 1972 valuation of $220,000, say that 10% of the value would be inadequate, and that 15 to 17% would be closer to adequate. $15 of 220 would have yielded a rent of $33,000 on the basis of 1972 valuation. Grunert's own expert testimony was entirely consistent with this. While he had made no estimate as to the fair rental value of the property for 1966 to 72, he opined that a fair rental as of June 30th, 1972 would be $20 to $21,000, which the tenant paying all expenses, including real estate taxes. According to Richard, SLE's real estate taxes in 1972 were about $12,000. Thus, Gunner's testimony to suggest that $33,000 as the fair market value, rental value in 1972, finally consistent with their view of the general downward economic trend. Richard and Allen conceded that whatever the property was worth in 1972, it was worth more in 1966. Thus, the evidence presented by defendants, far from carrying their burden of showing that 14.4 was a fair and reasonable annual rental in 66 to 72, suggested that the fair rental value of the property throughout the period exceeded $33,000 per year. The defendants argued, however, that LGT had not afforded to pay SLE rent higher than 14.4, and they produced evidence designed to show that LGT had made little profit, that this low profitability was due to the expenses and maintenance and upkeep of the property, and that LGT therefore would not have been able to pay a higher rent to SLE. The district court credited this evidence, finding that LGT had experienced a number of years of very severe losses, that during the period of 1962 to 73, LGT's overall profit was only $53,000, and the payment of rent at a rate of nearly $39,000 per year during this period could have led to the demise of LGT. So this is an argument that this would have been These findings have only a distorted relationship to this lawsuit, which is true. Untenable, I'll say. But it is only a distorted relationship to this lawsuit. It's kind of irrelevant. to the issue. The period in issue here, the only severe, which is 66 to 72, the only severe losses shown, totaling nearly 83,000, occurred in 1963 and 1973. Their inclusion in the computation of what LGT would afford to pay in 1966 to 72 is patently unfair. In fact, LGT's only unprofitable year during the period in issue was 1969, when its loss was small, 1,168. LGT's after-tax profits in 66 to 72, in fact, totaled $102,963, or an average of $14,709 per year. Thus, even on paper, LGT would have afforded to double its rent payments to SLE during the period in question. Moreover, the proposition that LGT could not afford to pay as rent more than what its own books showed as profits ignores the fact that LGT was owned and managed by members of the Lewis family, some of whom were also employees of that corporation. It is entirely possible that these family members granted to themselves unusually high salaries or other perquisites, thus reducing LGT's paper profits. For example, in 1966, Richard's salary was approximately $21,000. Leon Jr.'s compensation was $3,000, salary plus commissions. In 1967, LGT acquired all of Allen's LGT stock, and Richard and Leon Jr. acquired all of LGT stock of their father, agreeing to pay the purchase price over a 10-year period. Richard and Leon Jr. thus became LGT's only shareholders, and their LGT salaries were immediately increased by a total of $23,000 per year. Richard's salary went from $21,000 to $36,000. Leon Jr.'s went from $3,000 to $11,000 to cover the cost of LGT stock that they had just acquired. Defendants bore the burden of the question of a fair and reasonable rental if they would rely on the proposition that LGT was unable to pay more. It was incumbent on them to demonstrate the fairness of their management and the unreasonableness of the conduct of LGT's affairs. It does not appear that they made an effort to do so. Finally, even if we were to assume that so counter-argument, untenable, I'm just saying the untenable counter-argument requires more from defendants claiming it. Finally, even if we were to assume that LGT's financial records provided a fair basis for evaluating the SLE-LGT transactions, defendants would not have carried the burden of proof. Defendants did not demonstrate that SLE could not have found some other tenant stronger financially than LGT, which would have been willing and able to pay a higher rent. Even given the general downward trend of the East Avenue neighborhood, it is entirely possible that at least during the early years of 1966 to 72 period, such a tenant might have been secured. No effort was made during that period to rent to anyone other than LGT. We conclude, therefore, that defendants failed to prove that the rental paid by LGT to SLE for the years of 1966 to 1972 was fair and reasonable. Thus, Donald was not required to sell his LGT shares to LGT without such, or SLE shares to LGT without such upward adjustment in the June 1, 1972 book value of SLE as may be necessary to reflect the amount by which the fair rental value of the property exceeded $14,400 in any of the years of 1966 to 1972. We remanded the district court for the entry of judgment in favor of SLE against Richard Allen and Leon Jr. jointly and severally in such amount as the district court shall deem to be equal to the amounts by which the annual fair rental value of the property exceeded $14,400 in the period of February 28, 1966 to June 1, 1972 for an accounting as to the value of Donald's SLE shares as of June 1, 1972 in light of such adjustment for an order following such accounting of specific performance of the shareholders' agreement, and D, for such other proceedings as are not inconsistent with this opinion. So we're on page now 633, talking about Cookies Food Products versus Lakes Warehouse. Just trying to see where got another 14 pages before finishing what should have been read before spring break. This cookies case, actually even more than that, 17. No. We have even more than that. Actually 22 more pages. So I'm going to continue in another segment, finishing out self-dealing transactions with Cookies Food Products and going through the notes and beginning compensation, the section on compensation, and going through one case to demonstrate compensation.